All right, good evening, everyone, and welcome to the Thursday, May 12th Quarter Revision meeting. This is a quarter revision meeting held under the Drainage Board for the City of Kawartha Lakes for three municipal drain projects, the Hugh Davidson, the Martin, and the McEachern-Brown municipal drains. My name is Joel Watts. I'm the Deputy Clerk and Recording Secretary for the Drainage Board and the Quarter Revision, and I'll be beginning the proceedings for today. And in Council Chambers today with us, we have a Quarter Revision member, Councillor Pat O'Reilly, as well as alternate Quarter Revision member, Councillor Andrew Vail. And then on Zoom, we have Quarter Revision member Jim Oriotis, who is participating on Zoom today, as well as other Drainage Board member in the room right now. We do have Tim Wilcox, who is not a Quarter Revision member, but he is participating today, as well as Councillor Ron Ashmore, who is participating on Zoom as well today. And then we do have drainage engineers with us, Mike Garretts and Ken Smith, who will be speaking to their respective drainage portfolios today, as well as City Drainage Superintendent staff, Mike Farquhar and Rick Monahan. And other clerk's office staff are also in the room for the meeting today. So to start the Court of Revision, I'm now going to call the meeting to order. And to start the Court of Revision, there is a requirement for the oath of members of the Drainage Act Court of Revision, and at which point I will be asking the Court of Revision members to sign their oath of members, which they've all been provided with. And at which point now I will read the oath aloud, and then I will have the Court of Revision members just confirm whether or not they agree with the oath by saying "I do." And so there is also a Bible present if anyone would like to place their hand on the Bible for the oath today. So to the three Court of Revision members that we have today, Councillor Vail, Councillor O'Reilly, and Jim Oriotis, do you solemnly swear or affirm that you will, to the best of your judgment and ability, and without fear, favor, or partiality, honestly decide all appeals to the Court of Revision from the assessments arising from the provisional bylaws passed by the Corporation of the City of Kawartha Lakes that may be brought before you for trial at any time during your tenure as a member of such court? If you swear or solemnly affirm, please respond by saying "I do." Councillor Vail?
I do.
Councillor O'Reilly?
I do.
And member Jim Oriotis?
I do.
Thank you. If you could all sign the oath that you've been provided today, and then provide that to me. I can confirm that member Jim Oriotis, who is participating on Zoom, has provided his oath to me in advance and has signed that, and I will retain that for the file. And then to the two councillors in the room, if you would just like to provide those oaths to me. Thank you. Perfect.
I'm also on, Joel.
Yes, I acknowledged you just shortly before.
Okay.
We've got the three
That's fine.
appointed Court of Revision members. Sorry, that's Councillor Ashmore on the line. We've got the three Court of Revision members today, member Jim Oriotis, Councillor Vail, and Councillor O'Reilly, and then Drainage Board members who are watching today, Tim Wilcox and Councillor Ashmore.
Okay, thanks.
Thank you. And all right, so the next point of order for today's business is to appoint a chairperson for the Court of Revision for the three members. So of the three members participating today, would anyone like to nominate a person for the position of chair? Councillor O'Reilly.
I would nominate Jim Oriotis.
Thank you, Councillor O'Reilly. Jim Oriotis, do you consent to the nomination?
Yes. Yes, I do.
Thank you, Jim. Is there any other nominations for the position of chair for the Court of Revision? Calling a second time for position of chair for the Court of Revision, and a third time for the position of chair for the Court of Revision. Seeing no other members nominated, all those in favor, please say I do. Great, thank you. Jim Oriotis, you have been appointed chair for the Court of Revision for today's meeting, and I've given some guidance to the chair, and so I will let you take it from here. If you're okay to do that, you can feel free to ask me for any assistance during the process if you need. Thank you.
Okay. Okay. We're convening the court adoption of the agenda of the minutes. I call to order the May 12th, 2002 meeting of the City of Kawartha Lakes Court of Revision. Can I have a motion to adopt the agenda in today's meeting? Councillor Veal, Councillor. Okay. Sorry, I can't see it, but yes, it's been moved and seconded. Declaration of any pecuniary interest. Do any of the members have a pecuniary interest in any of the matters on the agenda today? Okay. So the next item is appeals, Court of Revision. The Court of Revision will now consider 3 preliminary adopted municipal drainage assessment schedules and any associated appeals. All comments received today by the Court of Revision may be considered as evidence in accordance with the Drainage Act. First one we're going to do is the Hugh Davidson Municipal Drain, Section 78 improvement. Appeals received prior to May 2nd, 2022 deadline. I see that no appeals were received by May 2nd, 2022 deadline. Any late appeals? Has the city clerk office received any late appeals?
We have received no late appeals for the Hugh Davidson Municipal Drain Section 78 improvement.
Does the engineer assigned to the municipal drain wish to make any final comment to the engineer's report and preliminary bylaw?
Through the chair and to the court, I haven't had any appeals as well, and I don't have any comments on the report.
Okay. With no further comments or appeals to be heard on this municipal drain, the Court of Revision will recess and make any final deliberations on this matter at item 3 on the agenda. Okay. Okay. Now, does anybody have anything to add or say while we're in Nope. Okay. Okay. Well, let's move on to 2.2, the Martin Municipal Drain. Appeals received prior to May 2nd, 2022 deadline. No appeals were received by the May 2nd, 2022 deadline. Late appeals. Has the clerk's office received any late appeals?
The Office of the City Clerk received no late appeals for the Martin Municipal Drain.
Okay. Does the engineer assigned to the municipal drain wish to make any final comment to the engineer's report and preliminary bylaw?
Through the chair and to the court, no, there's no comment, and I as well have not had any appeals.
Okay. Okay, with no further comments or appeals to be heard on this municipal drain, the Court of Revision will reassess and make any final deliberations on this matter at item 3 on the agenda. Okay. All right, we're getting to the good one. All right, we'll go to item 2.3, the McEachern Brown Municipal Drain. Appeals received prior to May 2nd deadline. Two appeals were received for the McEachern Brown Municipal Drain by May 2nd, 2022 deadline. The Court of Revision will now hear both appeals in order of their submission. Appeal from Carson and Margaret Thorne, Section 52.1, Appeal of Assessment. Deputy Clerk are the appellants, Carson and Margaret Thorne, attending in the meeting today.
At this point of the meeting, Carson and Margaret Thorne are not in attendance on Zoom during the meeting, and I have heard no other comments from them prior to the meeting as to their proposed attendance at this meeting.
Okay, so therefore like to say, would the parents care to read their appeal into the record? If they're not present, the deputy clerk, do the appellants have any other further comment on their appeal?
I can read the appeal into the record.
Sure.
Chair. The appeal was provided on April 27th, 2022. The notice of appeal from Carson and Margaret Thorne, they received the package on April 26, 2022. They stated in their appeal document that we have a 100-acre farm and a 1-acre lot on Centennial Park Road located on the east side of the road. We would like to have that reassessed as to how much land in the Conservation Authority allocated to be included in the total area that drains into this new municipal drain. There was no inspection of the property, and it was just based on maps. Our property will not benefit from a new drain installed. This spring is a great example of why this drain should be put back, as the only water line in the fields is on Mr. Brown property where the old open ditch was, and no water on Mr. McEachern's property. Water always finds its way and takes the best route. Your office should visit the site for a visual look. Since there is already a Bud Award drain and it has been used for years, it should be maintained instead of a new municipal drain based on the fact that it should be cleaned out and billed to the landowners involved. There are only two landowners who will benefit, Mr. Brown and Mr. McEachern. The rest of the landowners have to pay for two people is not right. Signed, Carson and Margaret Thorne.
For the record, do the drainage engineers, Mark Hoare or Ken Smith, wish to address the appeal at this time, even though the appellants are not present? Okay.
Ken here. I'm certainly through you, Mr. Chair, to the board. I'm certainly happy to answer questions if there's anything that would help in your deliberations. And I'm not sure whether you need me to walk through it point by point, but I am happy to.
Do any of the board members wish to review this point by point at this time, or is it okay to just continue? Okay, I see nobody wishes to hear any remarks about it, so I'm going to assume that we can continue on. Oh, okay. The next, I would have said, do the appellants wish to proceed with their appeal? They're not present, so we cannot, we won't be able to know at this time. Thank you for your comments, which we would have had. The court will now consider the next appeal. The appeal from Paul Lockoff, Section 52.1 of the Appeal of Assessment. Deputy Clerk is the appellant. Paul Lockoff attending the meeting today.
Mr. Lockoff is in attendance, and if you would like to turn on his video and unmute at this time.
Would the appellant care to read their appeal into the record, please?
Yes, I'd be happy to. I've slightly updated it, but My appeal is, it seems like the Wild West actually exists here in Kawartha Lakes. It seems you can drain water onto your neighbor's property, block the upstream flow from another neighbor with virtually no repercussions. Once your neighbor is drowning in water, you can petition for a municipal drain. I'm talking about Mr. Brown from DS&B Farms. The cost of this drain is enormous, which has upset many neighbors who see little benefit with costs they can never recoup. The truth is there's really only one beneficiary, and that's Mr. Brown. Mr. Brown, therefore, should bear the lion's share of these costs. Allow me some background, which for some reason was not captured in the report, even though it was clearly brought forward in face-to-face meetings that I attended. Much of this forms the basis of my appeal. In the summer of 2016, Mr. Brown tile drained his farm directly onto a culvert that he created on the side of Palestine Road. And subsequently, the water drains into the existing drain on my property. I notified Mike Farquhar, who's the supervisor of technical services at Kawartha Lakes, and Paul Harrelay, who was the drainage superintendent. They confirmed to me that one cannot drain onto municipal property or onto a neighbor's property. I was told the municipality was in discussion with Mr. Brown, but no changes were forthcoming. The water continues to drain onto the roadside and onto the drain on my property. Their suggestion was that I could block the flow of water if I chose to, which I did not. The point is that the water flow onto my property and into the existing drain was far higher than what the drain was actually designed to accommodate. This project is asking to accommodate this extra water flow, and Mr. Brown is the sole beneficiary. The existing drain was perfectly adequate to accommodate the flow it was designed for. In addition, the municipal drain will prevent me from reducing water flow from my neighbor. These details do not seem to have been considered at all. This result of ignoring these facts, I believe, has resulted in an unfair assessment of costs and greatly exaggerates the benefits to my property. I'd like to look also at the paragraph 4.1.2 of the report. This says that the drainage course south of Palestine Road, which is my property, has reportedly not been maintained, causing potential flooding of upstream landowner DS&B Farms. Reportedly, by whom? By Mr. Brown, of course. Is he talking about the enhanced flow that he created with his own waterworks project? Perhaps if one vastly increased the water flow onto a drain that crossed my property, it would overwhelm the drain. It's far more likely that it would actually flood my property than Mr. Brown. What's curious is that we spent $50,000 on an engineering study, and the engineers didn't actually verify with their own eyes or photos. It's very curious indeed that the engineering study appears to be quite comprehensive. Surely it would have been easy to photograph this flooding. There's perhaps a good reason for this, and that would be that Mr. Brown continued on with Waterworks Project number 2, which is the blockage of upstream water from Mr. McEachran's property. This occurred around 2019. As a result, virtually no water flows onto the property of Mr. Brown, and there is clearly no flooding for the engineers to observe. Perhaps for the $50,000 on this engineering study, we could have said that we could not verify the flooding on Mr. Brown's property because he replaced a 1 meter by 1 meter trapezoidal drain with a 0.4 meter pipe, which according to Purcell's law would reduce the flow by a factor of approximately 8. Little water actually now flows onto his property. Problem solved for Mr. Brown. He now has sole access to the existing drain. I would have expected the engineers to conduct a comprehensive study of the flooding, but not take Mr. Brown's word that there could potentially be flooding of his property. By the way, according to the study, the drainage superintendent was also called to meet with Mr. Brown and Mr. McEachran, as a result, the decision was made to apply for a municipal drain. I was not invited to this meeting, although clearly I'm a stakeholder. My point here is that replacing an existing adequate drain with one that accommodates the extra water flow from Mr. Brown's altered water creates a benefit for him and justifiably he should pay for it. I'd also like to address the allowances that are listed in Schedule A. I have an $8,800 allowance for a drain that tracks across my farm for loss of my farm's use. Mr. Brown has a $14,000 allowance. It's unclear to me what that allowance is for, because he's filled in the drain across his property, and my understanding is he is bearing the costs of moving it to the roadside. He actually gains farmland and does not have to deal with a drain that tracks across his property, and yet still gets a $14,000 credit. Seems he should be paying for farmland that was allocated to the existing drain and is no longer being used for that. Additionally, as I previously alluded to, Mr. Brown is to pay for the relocation of the drain across his property, and yet I wonder who's paying for the engineering costs of this change. Is that included in our shared $50,000 costs? Well, clearly it should not be. The report doesn't really include how these engineering costs were allocated. It really should be transparent, as one would think that determining flow requirements were far more challenging after the existing drain was actually filled in. Additionally, moving the drain across the Brown property to the side of the road required a floodplain impact study. What was the cost of this study, and where are the results? The results of the study may very well impact the cost of the drain, not to mention the time it's taken for this study to be completed, but this information is not included. Now, finally, let me turn my attention to the increased yields that are being attributed to my farm as a result of the drain. The existing drain works well. I've owned the farm for only 8 years, but I've spoken to the previous owner. The 233 per hectare per year in the 20-meter swath around the enhanced drain is simply non-existent on my farm. We've had some wet springs, especially after Mr. Brown enhanced water flow onto my property, but the hay that we grow doesn't fail. Perhaps if you grew almonds, you could achieve such numbers, but we grow hay. My farm makes $5,000 a year farming 80 acres of hay. Nobody could justify spending $24,000 on a drain and expect a positive return on that investment. Finally, let me comment on the property values, because I believe these numbers are flawed in the report. The report estimates that land that is drained is worth 20% more than undrained land, but no reference is provided, and the numbers are seemingly pulled out of midair. Drained farmland may in fact be worth more on average, but it was probably worth more before it was drained. If I owned land in the premium area of Holland Marsh, for instance, it would be well worth draining to maximize my yields. The point is that farmland was worth more in the beginning, and that's why people drained it. Taking average farmland values isn't really correct. One would really have to look at values in a single farm before and after drainage, and perhaps a realtor could provide such figures, but taking average figures across the province is really not correct. In summary, there's really only one beneficiary of this project, and that's Mr. Brown. As he stated in the previous council meeting, he seeks unfettered drainage of his farm, and the only way to guarantee that is given the illegal drainage onto my property is through a municipal drain. Mr. McEachern really only wants to see adequate drainage of his farm restored, and is a signature on this project as he is being flooded as a result of Mr. Brown's waterworks. Kawartha Lake's inability to enforce its own bylaws are part of this problem. The rest of the landowners are clearly opposed to this project. We saw that at a previous council meeting, and they feel they're being dragged into an expensive dispute they're not party of. Sure, we will get a fine drain, but it might be at an enormous cost. I would respectfully ask the committee to realign the cost of this project to adequately reflect the beneficiary, and that is Mr. Brown. Thank you very much.
Okay. Does the appellant have any further comment on their appeal? Okay. No? Okay. Do the drainage engineers, Mark Hoare and Ken Smith, wish to address the appeal?
Yes, thank you, Chair. Through you to the board, I have a number of thoughts and comments. First of all, Mr. Loco, thank you for your participation and input and concerns. very much understand. There's a few items. I'll try to take it somewhat in the order that you've raised the issues. I think perhaps the most pertinent, and firstly, I'd like to clarify that myself and my team have absolutely been on site. And on a few occasions at the outset of the project, at the on-site meeting, a walkabout to confirm the drainage conditions. And again, this spring, again, to confirm the flow and the extents of flooding. Mr. Lokoff spoke about adjustments to tile drainage and an increase in flow. And I'd just like to clarify that an adjustment to rates of flow is not the foundation of this petition. It's not material to the reason that this is moving forward. This isn't a product of more water or different water. So the increased tile drainage, I know that Mr. Lokoff and I have talked about that, and it didn't redirect water from outside the watershed in. It didn't change our drainage boundaries. That's not the catalyst for this. I'd also like to clarify, because this is a nuance to this assignment, we do have an existing channel in place. This is a former drain, the Eli Budd Award drain. And so there is a channel that exists. It's not likely the way it was when it was first constructed, but it's difficult to be sure the intent of that construction. The Eli Budd drain from 1904 has no profile drawings. We don't have the benefit of any design for that drain. And so it kind of within Mr. Lokoff's deposition, a return to the previous conditions is not something that it could be established with confidence because there isn't an assurance of what the existing condition was. So this has moved forward as a petition from DSNB Farms and Mr. McEachran regarding an improvement for drainage on their lands. And I think to explain the benefits a little more clearly, we understand that the benefits for this drain exist primarily for the McEachran property and for DSNB Farms. Our schedule of assessments, and if there's anything you want me to pull up in screen share and show from the report, I can. But 50% of the cost is allocated to those two individuals. 10% of the cost of the project to Mr. Lokoff is a product mainly of a benefit that already exists to his property. Mr. Lokoff has a component of the drain that has to traverse a downstream property before it reaches an adequate outlet. And it does that today, but will be formalized through this report, and that right of drainage will be continue. And so the benefit primarily is assessed on the basis of a continued assurance that drainage will be provided through this process. And that does exist for Mr. Lokoff's property as well. To touch on the benefits then, primarily the benefits are associated to Mr. Lokoff, to DSNB Farms, and to the McEachrans. Of the three, Mr. Lokoff has the smallest portion. But I'd also like to touch on the allowances that were described for DSNB Farms. So allowances are the values, the credit, if you will, provided to a landowner for various inconveniences. An important consideration is that the allowances primarily reflect land taken out of service by the drain. So it's the right of entry for both the existence of the drain and for maintenance in the future. And the drain, although on DSNB Farms, it won't be crossing where it historically did, it will be to the edge of the property. It is on DSNB property. So where Mr. Lokoff has indicated, he got his drain kind of off his lands or towards the road lands, it is very much on that farmland property. And so that allowance is for the access, the right of access to that land, for the temporary disturbance to crops from excavation associated with the land. I'll note that DSNB Farms had a reduced allowance, noting that some of the excavation would be in excess of what would have been required because we're moving the drain, and so they don't get credit for the extra material. The other thing I would point out is that there is a special benefit assessed to DSMB Farms of just over $23,000. That is in place explicitly for the additional floodplain study that Mr. Lokoff mentioned, the additional engineering costs, and additional excavation associated with their works. And so we recognize that there was more work that was required because of the relocation of the drain on their property, and that has been assessed to their lands. I trust and hope that that provides the information that will help the board to make a decision. Are there any specific other questions that I can answer that would help be of assistance to the board?
Does anybody have any questions at this time, or any regarding the appeal and the engineer's comments?
Could I make a comment, or is that just for council?
Would go ahead. Go ahead.
Well, I'm not really sure you really addressed my questions, but I mean, clearly, I think you hit the nail right on the head when you said the clear beneficiaries are Mr. McEachern and Mr. Brown here. And, having a drain placed on the edge of your property is not the same as having a drain in the middle of your field, whatever property allowance it is, because people don't generally farm right to the edge of the property. Anyway, and I've forgotten I wrote down the $3,000 cost of the study, but I guess, really the question is, we're faced with a $50,000 engineering study here. And how is that allocated, and how much more difficult it is to do an engineering study when you're moving a drain that was filled in. It would have been far easier to do if the drain was still there.
Sure. Yeah. Just for clarity, if you had mentioned 3,000, the number I said was 23,000. There's a $23,000 special benefit to DSMB Farms, which encountered our extra additional engineering costs, which is above and beyond the 50,000, and also the cost of the material. I did fail to mention, Mr. Lokoff, and through you, Chair, to the board, some of the values that you discussed, the property values, the increase in cost, value of the land, and the value of the drainage. I just wanted to clarify that if those numbers were reduced, as you suggested, if I were to assume that you were making hay and not almonds, as you said, that would actually increase your portion of the cost. The numbers of value have been used as part of your allowance, and the allowance is to your benefit. So I just thought I would perhaps caution that component of the discussion, notwithstanding the worth of the project holistically to the watershed. That perhaps is a different issue, but in this instance, we're talking about an assessment of value, and that's actually to your credit as we decide how to allocate the allowance fees. So thought I'd just add that point for clarity.
Well, good. Maybe I'll grow some almonds. Thank you.
Okay. Okay. Now, does the appellant wish to proceed with their appeal?
Is that towards me? Yes.
Okay. Okay, thank you for your comments. The court will now consider any additional appeals. Now, have there been any late appeals? Has the city clerk office received any late appeals as of yet? Okay.
The city clerk's office, as of today's date, has not received any late appeals or any other additional appeals. And perhaps Mr. Smith can confirm that his office received no other appeals as well.
Through you, Mr. Chair, to the board, I can confirm that our office has received no further appeals.
Okay. So just, okay, now it's clear. Right? Does the engineer assigned to this municipal drain wish to make any final comments to the engineer's report and any preliminary bylaw at this time?
Through you, Mr. Chair, to the board, no, not at this time.
Okay. With no further comments or appeals to be heard on this municipal drain, the Court of Revision will recess and make final deliberations on the matters heard under item 2. Okay, the Court of Revision will now recess for deliberations. The Court of Revisions will deliberate with the deputy clerk and the recording secretary and the city drainage superintendent. Those participating electronically will be temporarily placed on electronic waiting room and may wait for the court to reconvene. The engineer participating in person today are asked to leave the council chambers or remain outside closed doors until the court reconvenes.
Okay, thank you, Chair. We'll just make those preparations now, and then I'll advise you when the room is clear and the members participating electronically are in the waiting room. Okay, so Chair, I can now confirm that all the members of the public and the engineer are now in the waiting room. And we got the closed session slide. And then for our folks on YouTube, Jamie, we're back to live stream. Thank you.
Okay.
Okay, we have everyone back into the room who left the room for the deliberations, and those participating electronically can now see and hear us. Chair, go ahead.
Okay, I guess we'll start at the decisions of the Court of Revision. The Court of Revision will now reconvene to make final decisions, which we did. The Hugh Davidson Municipal Drain Section 78 improvement, decisions regarding any appeals, and decisions regarding assessments and provincial bylaw. I mean, if no further appeals are heard, we'll move on this motion. Can I get a mover? Council Veal. Council thing. Okay. Seconded. Okay.
Can
Now
someone
the-
read the motion, please?
Okay. Okay. That the assessments contained in the Hugh Davidson Municipal Drain Section 78 Improvement Report by the drainage engineer M. Garrett's and as provincially adopted by Bylaw 2002-050 are hereby confirmed, and that should any other appeals be heard within the prescribed timelines, that council proceed with the third reading of Bylaw 2022-050 at the next possible council meeting. Okay.
Can you call for a vote?
May I have a vote on that, please? Those in agreement? Those against? Motion carried. Okay. Now, we'll start with the Martin Municipal Drain. Any decisions regarding any appeals? Decisions regarding any assessments and provincial bylaw? If there are no appeals heard, we'll move on to the motion. Can I get a mover? Okay, Councillor Thing. Seconder? Okay, motion is carried. That the assessments contained in the Martin Municipal Drain Report by drainage engineer M. Garrett's and as provincially adopted by Bylaw 2022-065 are hereby confirmed. That should no other appeals be heard within the prescribed timelines, that the council proceed with the third reading of Bylaw 2022-065 at the next possible city council meeting. Okay. The next item, the McEachern Brown Municipal Drain. Decisions regarding any appeals. Motion to use if rejecting the appeal. Regarding the appeal of the Carson and Margaret Thorne. Can I get a mover for this motion? Moved by. Okay, and it's not seconded. Okay, moved by Councilor Thing. Seconded. Okay, that the Court of Revision for the that the Court of Revision for the Webster Municipal Drain make.
Sorry, the McEachern Brown.
Following decision. Okay, so we moved, we seconded, and
Sorry, you can read that again. Sorry, I just forgot to, in your proposed motion, to switch the word Webster to McEachern Brown. So if you want to reread that.
Okay.
Thank you.
I was wondering about that. That we, the Court of Revision, for the McEachern and Brown Municipal Drain, make the following decision with respect to the appeal filed by Carson and Margaret Thorne. That the appeal of Carson and Margaret Thorne be dismissed as the outlet and benefit liability assessments are consistent with the other lands in the watershed, and the owner failed to show justification for changes on their assessment. Motion to use if rejecting the appeal regarding the appeal of Paul Lokoff. Can I get a mover for the motion? Council Veal, seconder. Counselor. Beautiful.
And just a correction on this, proposed motion as well. I think Carson and Margaret's name is in there, but we can replace that with Mr. Lockoff.
Okay,
And then you can read it. Thank you.
okay. That the Court of Revision for the
McEachern-Brown.
McEachern-Brown Municipal Drain make the following decision with respect to the appeal filed by Paul Lotkoff. Sorry if I mispronounced his name. That the appeal of Carson and Margaret Thorne be dismissed as the
Sorry.
outlet will benefit Sorry.
Sorry, this is Paul Lockoff. Sorry, I just
Paul
need to make a
Lockoff.
correction
Okay.
there.
All right. Where was I? Let the appeal of Paul Lockoff be dismissed as the outlet and the benefit liability assessments are consistent with the other lands in the watershed, and the owner failed to show justification for changes to their assessment. Now, decisions regarding assessments and provincial bylaw. If all appeals are dismissed, move this motion. Can I get a mover for this motion? Councillor Thing, and seconder, Councillor Veal. Okay, that the assessments contained in the McEachern-Brown Municipal Drain Report by the drainage engineers M. Hoare and K. Smith, and as provincially adopted by Bylaw 2022-049 are hereby confirmed, and that should no other appeals be heard within the prescribed timelines, that council proceed with the third reading of Bylaw 2022-049 at the next possible council meeting. Okay. Other business. If the affected property owners are dissatisfied with the decisions made today by the Court of Revisions, anyone may appeal the decision to the Agriculture, Food and Rural Affairs Tribunal by filing a notice of appeal within the office of the city clerk within 21 days of the date of this decision. Okay. Adjournment. Can I get a motion for adjournment? Okay. Councillor Veal, Councillor Thing. Okay, good, perfect. Okay, I guess we're adjourned. Thank you.
Thank you.
Okay. It's a good thing I photocopied all this before.